Some new information now on the South Carolina church massacre of last year, with a competency hearing scheduled today for the defendant, focusing on whether he's mentally fit to stand trial. Dylann Roof stands accused of killing 9 black parishioners in a Charleston church in June of 2015. Since then, there have been a number of legal developments in the case, beginning 1 month after the deadly attack when a federal grand jury returned a 33-count indictment against Roof. About a week and a half later, Roof was arraigned on federal charges, and then in May of this year, Attorney General Loretta Lynch announced that the government will seek the death penalty. 4 months later, jury selection began in the case. But about 2 weeks ago, that was delayed after the defense filed a motion questioning Roof's mental competency. That led the judge requesting a mental evaluation of this defendant. Joining us now, Jonna Spilbore, former prosecutor and criminal defense attorney. Heather Hansen is also with us. She's a trial attorney. Heather, the people who are affected by this, parishioners of this church where the shootings took place, said they are lying awake sleepless at night because they don't know what's going on, and this process is sealed. It's secret. Why?
This part of the process is sealed, and that's unusual, John. Usually these competency hearings are open to the public and are open to the family members. This judge has said that he feels as though if this was open, it would bring a deep and bitter prejudice to the community. That means that Roof is going to say something or has said something that is extremely offensive, and he feels it unnecessary to expose people and potential jurors to those things that he said.
But in the meantime, Jonna, jury selection was already underway. They've got 500 people cooling their heels who are supposed to not read anything about the case. How do you do that with a jury pool of that size?
Yeah, that's a fantastic question. And that's an interesting thing about having a competency hearing is it can happen at any time. You have to keep in mind, this isn't about whether he was sane at the time he committed the offense. This is something entirely different, which is why jury selection can be put on hold to make this determination before they continue on. Because if he's not competent, John, there is no trial, at least not for right now.
But this isn't a guy who just walked in off the street and started shooting. He did that after a fashion, but he sat there in this Bible study group for an hour. You can't get much more premeditated than that, can you?
And that's right. And that goes to Jonna's point. This is not about whether or not he can bring the insanity defense and say, I didn't premeditate this, I didn't know what I was doing. This is whether or not he can participate in his defense. We saw this with Jared Loughner after he shot Gabby Gifford and so many others. He actually went through a number of competency hearings before he was held competent. This often happens, and everyone should want him to be found competent or be made competent so that he doesn't have an appeal and that we don't have to go through this again.
But if the hearing is closed, Jonna, how is the rest of the world supposed to know whether he's actually competent or not?
Well, certainly the ruling will not be closed, right? The judge will have to disclose that. And this judge has even said if he's found incompetent, he will, or regardless, he will reveal the transcript so that people can go back and determine what was heard at this hearing. But personally, what I think this is a move. Look, we have the state and the feds both jockeying for the death penalty, which is unusual enough. This kid has already said, look, you take the death penalty off the table, I will plead guilty. So how incompetent can he be at the moment? I think this is a move to try to force the hand of either the state or the federal government to either take the death penalty off the table or come to some sort of agreement without having to put the community through a trial.
Do you see it that way?
I do, but I don't think it's going to work. I think that both Loretta Lynch and the prosecutor in South Carolina are hell-bent on pursuing the death penalty. This is despite meeting with the family members, many of whom you'll remember don't want the death penalty. They're very religious people, and they have actually said that they don't want it. I think that this judge is being so gracious and so correct in allowing all of the family members to speak, to voice their concerns about the fact that this is closed, and at the same time trying to protect the appellate process and the community by not having this competency hearing open.
Let's just say that the federal judge finds him not competent to stand trial or something like that. Does the state have to abide by that? The state of South Carolina could put him on trial as well,
but
right?
I think as a practical matter, that would open up a whole Pandora's box on appeal, because if you have a guy sitting in a psychiatric unit because the feds think he's not competent, and you bring him on trial on the state charges, I don't see how that would fly. I think at the very least the state would have to postpone their trial, which is slated for January.
And remember, this isn't forever. Every 4
Right.
months, he will be brought back to see whether or not he has become competent. They will treat him with drugs. They will treat him with therapy. And oftentimes that happens if they come back and they are competent. So I agree with John. I think that this would go 4 months if he's found incompetent. I also don't think he will be found incompetent. I think that there's enough evidence that he's doing just fine.
Why are the feds pushing this death penalty case so hard? I mean, it's pretty hard to get the death penalty in a federal case, isn't it?
Very much, and that's the thing. The state has already put the death penalty on the table. You would think the state has enough legal muscle to get the job done from the federal perspective, but maybe the feds don't think that that's going to happen for whatever reason. Maybe they're going to have a more sympathetic jury on the state side, and the feds want to make sure that this guy thrives.
I think it's also symbolic. You know, they want to show that we will not stand for this type of crime.
Right.
All right. We'll continue to keep an eye on this.
Case.
Yeah, really a sad case. John Spilmore, Heather